We will go on the record in the matter 25 CF 41, State of Wisconsin versus Heather Honeycutt. The state appears through District Attorney Kevin Schmidt in person. We have Ms. Honeycutt appearing in person in custody with counsel Tripp Stroud. We're set today in this matter for the sentencing part of this case. Ms. Honeycutt pled guilty to count 1, burglary of a building or a dwelling, she pled guilty to theft, movable property greater than $100,000, a felony F or an F felony. The court set this for the time to have the sentencing hearing. The court has received and reviewed the sentencing memorandum filed by Mr. Stroud. The court did not receive any other memorandum or did not order a pre-sentence investigation report. We are in victims' rights compliance.
Yes, Your Honor.
Is the victim or one or more going to be making a statement?
Yes, John.
All right, the victim can go have a seat on the black table. You can either state your full name and spell it or just go by your initials.
Thank you, Your Honor.
And I'm going to ask you that if you are reading something, that's fine. Just make sure that you do so slowly and enunciate your words. My court reporter needs to take everything down word for word.
Yes, ma'am.
Okay.
Yes, Your Honor. Hello. Thank you for your time. My wife and I are local business professionals and taxpayers of the
First,
county.
your name
Oh,
or
sorry.
initials.
Timothy Fry, F-R-E-Y.
Okay, thank you.
My wife and I are local business professionals and taxpayers of the county. We give back to our community by donating time and money to local organizations, including Lakeland Family Resource, Sacred Heart Church, the Spooner School District, Scott and Spooner Fire Department, snowmobile clubs, and the city and county law enforcement. My mother, Mary, is a widowed, retired special education teacher who taught in the Frederick School District. I have never met Heather Honeycutt, and she has never had my permission to be on my property. My only knowledge of her is that her and her boyfriend are friends with my former contractor. In March of 2024, I went into my pole barn and the door was unlocked, which I thought was strange. After going inside, I look over and a lot of my property has been moved around. And in the corner of my barn, I saw that my mother and my family's safe has been dug up and stolen. After my family passed away, I had major issues with the bank getting access to my safety deposit boxes. So I just decided to buy a safe, put all the estate items into it, and bury it where no one knew where it was. Inside of the safe was my 9mm handgun, my grandmother's multi-generational diamond ring, my great-grandfather's watch, and gold and silver coins, and multiple other family property that is irreplaceable. The only people who knew where that safe was located was my wife, my mother, and my father-in-law who helped bury it. The thieves were able to get into my pole barn without any forced entry. And the only person that had a key prior other than my family was my former contractor who was friends with Heather. The thieves or Heather somehow knew right where that safe was located in the back corner of my pole barn, buried underneath a foot of dirt where I had heavy machinery and deer stands on top of it. It was located where no one would ever know where it was, and it hadn't been touched in years. There's no possible way any one person could have lifted that safe by themselves, and I know Heather had help in stealing this safe. And I would gladly agree to no sentence if she would just tell me who the main people are responsible. My mother is a widowed elder woman, along with myself, my wife, and my 2 young children, age 5 and 2. Knowing that Heather and other thieves had came onto our property and stolen a firearm, along with my family's legacy, makes me extremely anxious, afraid, and we do not feel safe in our own home. I've had to spend significant amount of money to install additional security measures so our family can still continue to live at this residence, but in fear. Since the initial theft, we have been targeted again and another shed broken into with no other neighbors broken into, and the person on the footage has a very high resemblance to Heather's boyfriend. Law enforcement is very aware of the other parties involved, and these people have no respect for law-abiding citizens. The anxiety and fearfulness that they will target my family again is overwhelming, considering I have two very young children and an elderly mother. The dollar amount of this theft is also extremely high, but the monetary amount doesn't really matter to me as much as my family heirlooms, as I would give anything to have my grandmother's multi-generational diamond ring back, because I was going to give it to my son to give to his future wife someday. The amount of this theft, as you stated, qualifies as a Class F felony. And again, I would just tell, again, if she would just tell us who the main people are responsible for this theft is, I would gladly agree to time served. But with the amount of theft, no cooperation on naming the others involved, no recovery of the firearm, and never being able to get my family legacy items back, I think the plea is light in terms of sentencing if she is going to take full responsibility for this. I thank you for your time.
Thank you. Mr. Schmidt, argument and sentencing recommendation, please.
Thank you. This is a joint agreement for 18 months initial confinement, 42 months extended supervision, and costs. This comes with a stipulation as to the base restitution amount, the first amount that Mr. Frey reported, which comes from an old estate documentation because it was all inherited items. This is a case where Heather Honeycutt is accepting responsibility for being involved in a theft that necessarily took multiple people to execute. And she's the one who happened to leave behind evidence. A cigarette butt at the crime scene where she told law enforcement she'd never been, the presence of her phone in the same area where she said she'd never been to, suspicious messages between her and the only other man who's not in Mr. Fry's family who knew where the safe was buried. And then some of the stolen property started to be recovered to people that can be connected through her 7 degrees to Kevin Bacon style through phone logs, Dakota Barf to Justin Pfaff to Heather Honeycutt. Law enforcement obviously has strong suspicions about certain people connected to Honeycutt who have substantially more criminal history than her as being the main people involved in planning and executing the heist, as well as the contractor who knew where it was buried. We've talked about that length when we talked about previously at the plea hearing and why it's in the public interest for this plea agreement to be. The reason there's only enough evidence to convict her versus them is likely because of their greater experience and skill at avoiding incriminating themselves. Basic things like not talking to the police, not keeping their cell phones on their persons when they're committing crimes, not leaving behind physical evidence. This is the primary reason for the joint agreement. This is clearly not one of the main people primarily responsible for planning, thinking up, and executing this heist. If it was, she would have posted bond long ago, as her bond that she's being held on cash for is a fraction of what this property was worth. Instead, the stolen merchandise has been, stolen property has been showing up in the hands of other people who are either more responsible or are friends of people more responsible. That being said, given the nature of the burglary, literally a safe heist of possibly the largest amount of valued property stolen in the history of our county, probation would unduly depreciate the seriousness of the offense. It needs some period of incarceration. The victim isn't even asking for everything that was stolen in the safe. The only things he felt he could prove in his mind and is asking for are the things he previously had appraisals and lists of through the estate. He had many other items that he could have attempted to get restitution for and did not. Therefore, he's never actually going to be made whole, not just because of the financial value, but also the sentimental nature of many of the items taken. You heard of his grandfather's watch, the multi-generational ring, things that he will not be able to pass on to his children. So what is the appropriate penalty for a person who is 41? She has only one prior conviction, and it's possession of marijuana from 12 years ago, whose extent in the involvement of the theft seems to be either minor or aiding and abetting in that nature, who is going to be on the hook for a substantial amount of restitution no matter what. I think given the gravity of the offense, as well as those mitigating facts with her 18 months initial confinement is appropriate. She's already sat a little over a year. There will be additional punishment in the form of some 5.5 months or so as a result of the court following the parties' joint recommendation and sentencing for this period of time. These accomplish the goals of specifically deterring this person while also meeting the statutory requirements of being the minimal amount of confinement necessary to achieve the goals of the sentence. There will also be an extended period of time of extended supervision if the court follows this agreement, which will give a watchful eye on her and make sure she steers clear of the bad actors who have roped her into this crime and hopefully will not rope her into future crimes. According to the sentencing memorandum, that has been claimed as one of the primary causes of her negative outcomes in her life. That and substance abuse, which is another issue that can be addressed on extended supervision. So for those reasons, the state would ask that you follow the joint agreement. Thank you.
Thank you. Mr. Stroud?
Thank you, Judge. The sentencing power that you have is an awesome power. It's the power to destroy a life. And it is also, at the same time, the power to rebuild one. The discretion that you have over Heather's life right now is at its absolute height. And I ask you to use that power to help rebuild her. The first thing that the court needs to consider is the rehabilitative needs of the defendant. As the state indicated, we're not proposing that probation is something that's needed here, but I do think dwelling on Ms. Honeycutt's rehabilitative needs is something we still need to do. I think they're strongly indicated by this case and by Heather's history. While she has been in custody awaiting this day, there's been a limited amount of services that she could have received in the jail, but the ones that were available, she took full advantage of. And I think you can see that from the letters that were included in the sentencing memorandum. And her participation and engagement, I think, speaks to the thirst that she has for those services. If we could have managed to get her out of custody, we would have put her on a program where she would get counseling, therapy. She would receive separately AODA counseling and therapy. We would encourage her and check in on her. Weekly job applications, seek employment, maintain full employment, and then give us social proof that the people that she is associating with are going to help her on her path and prove to you that she's a good person. We weren't able to get her out. Therefore, we weren't able to do those services. But I think the recommendation that we are offering and proposing to the court will get those services to her eventually. The larger proportion of extended supervision in this case, I think, will address the needs that she has: sobriety, maintaining supportive relationships, running to the good people in her life, running to the good things about life, and running from the bad. Let's talk about the gravity of the offense. Thou shalt not steal. It goes back to the 10 Commandments. That is how ancient this offense is. And it's something that we think of today when we talk about the kind of place where we want to live. We say it's the kind of place where you can leave your bike in the yard. And that conjures up all kinds of thoughts and visions and images about the kind of place that we want to live, or you would want to raise a family. And the reason why we say it that way is because in a place like that, you're free from the freedom that things will get stolen. So it is a grave offense. And the legislature has seen fit to classify this offense as a misdemeanor, depending on what's been taken. What makes this such a serious offense, what makes it a Class F felony, is the value of what was taken. Not necessarily that any aggravating factor in terms of how the theft was carried out or what was done with the property or to who. It simply comes down to dollars. So I ask you to keep that piece of it in perspective. No one was physically harmed. No one was threatened with harm. There was no violence alleged by anybody. No threat of violence alleged by anybody. The need to protect the public. What rings throughout the letters written about Heather is that she is not a danger to the public. Heather's mother and her daughter, Candace, wrote to you, Judge, and I am just as miffed as they are that Heather wanted to plead. This case to me is one that should have been tried. And I think what would have come out at the trial, regardless of the verdict, is that the public does not need to fear Heather. And what we are asking you to do here today with Heather in her life and the course that you're going to set her on, I think addresses the public's need to keep Heather separate for a while. The character of the accused. True character is how you act when the chips are down. The chips have never been this down for Heather. We've done our best to tell you her life story in the sentencing memorandum, and there have been some downs. There have been some downs, but the chips have never been this down, Judge. But it's how you act when you're in that spot that really shows character. And so I want to draw your attention to page 14 of the sentencing memo. Page 14 is a letter from Crystal, who, as far as I can tell, was a perfect stranger to Heather. And I want to quote things that Crystal had to say about Heather when she met her in the jail. It was probably Crystal's low point in her life. And what she said about Heather was, she reminded me that I still had value and purpose. When I felt I was falling apart, she was there for me. For someone that doesn't have strong character, what Heather has been through, waiting in the jail, waiting for this day, would have been an opportunity to wallow, would have been an opportunity to have the world's biggest and longest pity party. But what I hope you see from the sentencing memorandum is that what Heather has done with her time waiting for this day is to try to build people up. To build people up. When they're falling apart, she was there for them, even a stranger. In my book, that's character. And that's a foundation you can build on. I ask you to adopt the joint recommendation. It's appropriate given the gravity of the offense. It's appropriate given the public's need for protection. It's appropriate in light of Heather's character. It certainly meets her rehabilitative needs and can be structured to meet those needs so that for a long time from now, the path that Heather is committing herself to, she has the structure to stay in that path. That's it for my comments, Judge. I really hope that you accept this recommendation, but I'm going to hand it over to Heather, who has something that she would like to say to you and to the rest of the people here today.
Thank you. Ms. Honeycutt, you have the ability now to give a statement, to let me know anything that you want me to know before I sentence, to let me know anything that may have been said incorrectly or you want to add to. This is your time. If you are going to be reading something, I am going to ask you to read it slowly and enunciate your words. Again, my court reporter needs to take everything down.
Yes, Your Honor.
And please speak into the microphone.
Thank you. Thank you, Your Honor, for giving me the opportunity to speak today. I want to start by saying that I want to take accountability for the wrong choices I've made that have brought me here before you today. To the victims, I truly and deeply apologize to you and your family. Also to the community and to my family. I know my actions have affected them as well. Before being incarcerated, I was headed down a destructive path. I knew I needed a change. I sat and prayed, asked for a way to help me change this path. I was going down. I never expected it to be going to jail, nor did I want it to be that kind of circumstance, but it was. I needed a wake-up call, and I definitely got one. This last year has been one of the hardest and most life-changing lessons I've had to go through. While being in here, I lost everything. My home, my family was divided. I was abandoned by someone I love. My oldest daughter had to take responsibility of taking care of my youngest daughter while taking care of her own child. I stood in front of the mirror and I realized I had to face myself. I had to change myself because this is not who I was or who I ever wanted to become. The time I've had in here gave me the time to truly dig deep inside, to really find myself. I had to remind myself where I came from, to go back to my roots, to what I was taught from my family, to return to the spiritual faith that my family was so rooted in to help me to truly change. I've always tried being a strong woman, but it was always trying to do it on my own. Remembering what my family taught me is that the greatest strength you can find to lead you on the right path is that anything is possible through Jesus Christ who strengthens you. So I opened my Bible and I began to not just need, but want God's help to make the changes in me that I so desperately needed. I want to share a couple verses that helped make a true change in me. Hebrews 12:11-13. No discipline is enjoyable while it is happening. It's painful. But afterwards, there will be a peaceful harvest of right living for those who are trained in this way. So take a new grip with your tired hands and strengthen your weak knees. Mark out a straight path for your feet so that those who are weak and lame will not fall but become strong. This last year has truly changed who I am and who I want to be. It's also opened my heart to what God has called me to do. While being in here, I've attended Bible studies and groups that I'm very thankful for. They helped in growing my faith and my mental and emotional strength. When I said that God opened my heart to what He's called me to do, I say this because also while I've been in here, I've met a lot of different women going through their own battles as well. And I realized that God gave me a gift of encouraging others through my own testimony. Also, while being in here, COs have pulled me aside to talk to other females, to help talk to them, or have put certain inmates in my pod, knowing that I'd help take care of them and encourage them and nurture them. When I am able to get back into the community, I want to be able to help others. I've already connected with a church and groups that will continue to change, that will continue my change and growth and foundation for change. I want to begin working immediately and start building a stable life for my family and I to have. Once stable and able to move even further and moving forward, I would like to go to college to become a counselor. I believe that my testimony of what I've been through can help others. I've been that woman who has been through rape, mistakes and I made wrong choices, but I also made the choice to change. This year has been the stepping stone that has changed and will continue to change my life in the hope to help make a change in others. As it says in Ezekiel 36:26, and I will give you a new heart and I will put a new spirit in you. I will take out your stony, stubborn heart and give you a tender, responsive heart. God cleansed me this past year so that today I can say thank you and look at this year as a discipline that turned into a blessing. Thank you, Your Honor.
Thank you, Ms. Honeycutt. I reviewed a sentencing memorandum that was 6 pages with the additional pages, and I think I counted 8 character references, character letters. I'm not going to how do I say this? You have been through a lot in your life. You have had pretty much as much trauma as one can possibly have in your childhood. Granted, there are people I'm going to tell you that have come in front of me that have had it worse, you know. But your life wasn't easy. It's hard to see that though with your family as supportive as they have been your entire life, and you recognizing or identifying yourself as the black sheep or the one that is the one to deviate or to rebel or to tell yourself not to be in the same category or on the path as the rest of your family. Pregnant at 15, that's hard. That's very hard. And being sexually assaulted, trying to even support yourself, continuing the path of destruction with toxic relationships and substance abuse. And I know you credit Justin for being a person to help you move away from your heroin addiction, but he still wasn't good for you.
No.
He still continued to bring you down the wrong path, and forefront became methamphetamine and other crimes, other things. I've heard the argument of the state and the argument of your counsel, and I've heard your very heartfelt statement to the court. I commend you for having the self-reflection that you have had the course of this year. And I also commend you for stating yourself, as well as through counsel, that essentially being incarcerated, being in jail saved your life. It may have been the worst thing that you could have thought of at that time, but it has been the best thing for you. I want to let you know that you're not in the same boat. People sitting in that chair in orange a lot tell me that, and I believe it. But for the fact that you were incarcerated and having the forced sobriety and the ability to engage in those Bible studies and those parenting classes and the AODA and those other things, you probably wouldn't have availed yourself to them. You have to change your habits. You have to change the people you associate with, and you have to change yourself. That is the only way to be better and have a better life. It will significantly improve your life if you do those 3 things. But not only do you have to modify your own habits, you have to actively surround yourself with people who support your positive change. people who align with your goals, people who greatly influence your behavior and your mindset in a positive way. I really want to see you as a counselor, Ms. Honeycutt. Not only have I heard from the character references, but through your counsel or through you, that you are a very encouraging person to others in despair. You're able to listen to them, provide them guidance, while you are yourself facing the same thing or worse. So that tells me a lot about you, Ms. Honeycutt. You have the goal and the desire to be a therapist. Don't lose that. Change your habits, change your associates, change yourself. And hearing the statement from the victim, and I'm sure it had an impact on you as well, it's not so much the money. It's a lot of money. Over $100,000, perhaps more, maybe up to 200,000. I don't know. I haven't had the restitution hearing yet. But it's not about that dollar amount. The victim and his family have lost so much more than money. You can always, always make more money, earn more money, do more things to get money. You can never have money replace security, sanctity, heirlooms, a ring that was passed down from generation to generation. Things that are irreplaceable because it's not the value of that item, it's the worth to the victims. And I can't say with any amount of anything that the second burglary or attempted burglary at the victim's property is in any way related to this. You're in custody. You were not involved in any of that. However, sometimes it's been shown in our cases over and over again that once you're victimized, sometimes they get hit again by others or by the same people. And that continues to destroy the victim's sanctity, their feeling of security. I mean, if you can't bury a safe in the ground, far under the ground, and put heavy machinery over it and other heavy things to protect it, other than a safe deposit box, and some people don't trust banks, where are you going to put it? Because if people find it and they are able to get it there, they're able to get it anywhere. And you are a part of that, Ms. Honeycutt. Whatever role you played, you were a part of that, a part of destroying the victim's sanctity. I have to look at the nature and the gravity of the offense first, and then I look at your character, your prior record, rehabilitative needs, and I also have to look at needing to protect the public. Other factors include the effect on the victims, any undesirable behavior patterns, and deterrence. There's specific deterrence to specifically deter you from continuing down this path and committing either this type of crime or other crimes, or general deterrence, a message sent to the community to generally deter others from doing the same thing. And both parties, both counsel are correct in the fact that I must first consider probation. I have to first look at probation to see if that is a potential alternative to sentencing. Unless confinement is necessary to protect the public from you and from your further criminal activity, unless you need correctional treatment, meaning that you need to be in a correctional facility to get that treatment, you haven't sought to get it elsewhere, or if probation would unduly depreciate the seriousness of the offense. I fully believe, Ms. Honeycutt, you were a minor role in this burglary, in this theft, but you played a role. You had other actions and conduct that you could have done to prevent this, or to step aside and not be a part of this. But you chose the alternative. You could have called the police. You could have let the victim know that something may happen and he could move the safe. You could have told somebody else that you trusted and have them disclose this information. You could have simply walked away. But you engaged in this activity, this criminal conduct. But doesn't mean that you should be thrown in prison and shut the door and lock it and throw away the key. I don't think it does. It was very clear in your attorney's argument today, as well as the sentencing memorandum, that you are a person who either the court and the community can destroy or help rebuild. And I'm going to tell you, I heard from the victim here, I don't believe he wants to destroy you. I don't believe he wants to see you go to prison for the rest of your life or for the maximum penalty. I believe he fully wants you to rebuild yourself, change your course, and be a better person and help the community, be a counselor, help others, so you can help stop this from happening to other people. I truly believe that. He also would like, other information, because the unknown is what worries us the most, or something like that is the quote. Because you were not the sole perpetrator. You were not the sole criminal involved in this incident. There were others. 1, 2, 3, how many? No one knows, but you and maybe your counsel. You are not falling on the sword, Ms. Honeycutt. You do not have to take that upon your shoulders, Ms. Honeycutt. I don't even believe this was your idea, Ms. Honeycutt. You do not need to protect others who have failed you, who have seen you sitting in that chair time and time again, knowing that you could go to prison. You do not have to protect those that failed you, who did not care one bit about you taking the blame wholeheartedly. I truly believe, Ms. Honeycutt, that you do have a lot to offer people. Not only when you are out of custody, but when you are in custody. This is a case where I understand the objective of the agreement. You are a small party, a little potato in the big crock pot of pot roast. But it's still a crime you are accepting sole responsibility for. So So should that mean that the court should assess all of use all of its power and authority to sentence you to a heavier sentence? Or should the court follow the recommendation of the parties? You still have your family who supports you. No matter what you do, they support you, and that's positive. Again, not many people sitting in that chair have that either. And I have to look at treatment options and the ability to avail yourself of the programs in prison, because I can't guarantee you're going to do that when you are released, and I can't order that as an extended supervision condition. You need treatment. You need some type of treatment. And right now, it's the only option would be incarcerated and perhaps the substance abuse.
Can I say something?
You may.
I did get accepted into the Restored House, and it's a 3-month program that helps with, it's a treatment program.
And that's good after the fact. But right now, I'm telling you, I'm looking at time, and I'm looking at time to be able to engage in the substance abuse program while you're incarcerated in prison. 6 months won't do it. 6 months won't do it. Adding in your jail credit. They look at the amount of time you have and the ability to complete the program. And there must be at least 1 year. So what I'm going to do is I'm sentencing you to 2 years of initial confinement. I'm giving you a step up. It seems like a harsher sentence with 6 more months to have to sit, but you may not have to sit that if you engage in the program. I want to see you engage in that program, Miss Honeycutt. You are 40 years old. If you don't take control right now, it will take control of you. Time after time after time. So 2 years of initial confinement, followed by 3.5 years of extended supervision. $518 in fines and fees. We need to schedule a restitution hearing sometime soon. I can't force you to engage in that substance abuse programming. You have to want to do that, but you're going to need to start that process as soon as you are brought to prison. Absolute sobriety. No use or possession of any drugs, paraphernalia, or medications without a prescription. No contact with anyone on felony supervision, on extended supervision, or probation without your agent's approval. Gainful employment or continuing education. Regular drug testing. No contact with the victims, their residents, or their businesses. And I don't know what those are, so we may need to figure those out so we can write them and have them spelled out clearly. I am also ordering that you cooperate with law enforcement regarding potential of others involved, and cooperate by providing information if you have it or know of it as it relates to the heirlooms, the firearm, the ring, the other heirloom items that were mentioned. Can't order you to disclose, but I can order you to cooperate. And I'm going to tell you, Ms. Honeycutt, you have to look out for you, number one. You are number one. Your kids are number two. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. This is a felony. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. Again, clearly stated sentences, twofold why I did 2 years in. Because it gives you an opportunity to engage in the programming, and because it would unduly depreciate the seriousness of the offense if I did put you on probation or a lesser offense or a lesser sentence. I mean, I have 384 days. How many days jail credit do you have?
That's what I have as well.
Because I think I got it correct.
386 days.
386 days of jail credit. As to the fines and fees, they're to be collected by the Department of Corrections at a percentage determined by the Department of Corrections to be reasonable while you are incarcerated, and it is a condition of probation to pay that off. However, I'm going to tell you right now that that includes restitution. We don't know what restitution is because we have to set that hearing. I need to order your DNA. The jail will make sure that they get that. You have the right to request it be expunged through a written letter to the Department of Justice. This is a Class F felony. I don't believe that option is available, but it's up to you to find out. Mr. Schmidt, what am I missing?
For the addresses victim wants no contact, can we just get that to the clerk another day or?
Yes.
Okay.
Victim is here, so victim can easily provide it. So I'll just give a day to provide it, and then we can make sure we have that information. Felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. Anything else, Mr. Stroud?
Yes, I have.
Oh, and eligible for the substance abuse programming or challenge incarceration program.
Thank you. In addition to that, the condition on cooperating, can we revisit that? I've never seen or heard of that. I don't even know if it's a
We've
lawful.
done it multiple times here.
All right, so can I ask some questions about it then?
Yes.
It's a significant condition because if she doesn't cooperate, then she could get revoked, right? So I want to make sure that I understand what that can.
I can't force her to say anything.
Then what is, then so Heather understands and we make it clear, what does it mean?
Cooperate means if they say, hey, Miss Honeycutt, let's have a talk. There's a talk. Let's talk with law enforcement if they want. How would you like it defined, Mr. Stroud? Mr. Schmidt? How have we used that language before?
I think what he's probably concerned about is he doesn't want something that could be argued to violate her Fifth Amendment rights not to incriminate herself,
Then
because
she
even
can plead the fifth. Cooperate means if they ask to talk, she talks.
Right, but as Attorney Schmidt's saying, she has a constitutional right not to talk, and
Ding, ding,
who,
ding.
right?
Why you can't force her to talk?
Okay, so what I heard you say was that if law enforcement says, let's talk, she needs to talk to them. But I'm also hearing it wouldn't be a violation if she says, I don't want to talk.
They say, Mr. Stroud, hey, Miss Honeycutt, let's have a conversation. I'd like to talk to you about this case. They can call her into a nice little room and they can be face to face and have a nice little conversation with her. She doesn't want to talk because she thinks she's going to incriminate herself. She can plead the fifth.
All right.
It's happened multiple times in multiple cases. Or she can say, you know what, I need to talk to my lawyer, but I'm here talking to you.
All right, so her obligation under this condition is to, if law enforcement asks to meet with her, she has to take the meeting. She has to be there in the meeting. but she can plead the fifth and not.
That's her
Provide information.
constitutional right. That's why I specifically said I am ordering her to cooperate with law enforcement concerning if they want to talk about those things. I can't force her to disclose. You can't force her to disclose, even if law enforcement can't force her to disclose. But to cooperate, have a nice little chat. She can talk about the moon if she wants to. But if they want to meet with her, they can meet with her. Meets with them, and she says, I plead the fifth. Or I'd like to call my attorney. Yeah, with her constitutional rights. Well, see, we shouldn't have to define that, but anything else? Thing is here, you and I both know I don't have the authority to order her to disclose exactly what happened and when and who's involved and where the things are. You know that, I know that, Mr. Schmidt knows that, probably anyone else in here knows that. But I can order her to cooperate. She can't go, nope, I'm not going to talk to you and have a fit or do whatever. You understand, Ms. Honeycutt?
Yes.
But if at some time she wishes to disclose, that's her right as well. Don't know what's perplexing because this has been ordered multiple times and asked for by the state multiple times in multiple cases, at least up north.
I'm sure it has. I've never encountered it before, and I think it's a fair question that she understands because the consequences of not cooperating.
My job isn't to inform her of her rights. That's your job.
Yeah, I understand, but
My job is to look at the victims and make a condition, and you tell her what is within her constitutional rights.
unfortunately, I don't run the Department of Corrections. I see them make wacky decisions and interpretations of court conditions all the time, and so this one concerns me. We've made a record of it. You've said that she can exercise her constitutional rights, and if this ever becomes an issue in the future, it'll be in the JOC, it sounds like.
Sounds like it will. Never had to do that before. An attorney has never questioned that because they usually counsel their client and say, you have the right to your Fifth Amendment right to remain silent.
Well, I guess I'm different.
All right. Anything else?
No.
What? Oh, yep, we need restitution hearing.
Judge, I thought we had scheduled that for today. I'm prepared to move forward today.
I had thought we were going to schedule it at a different time. If I knew the plan was to proceed today, I would have asked for a continuance because the way the victim assessed the value of the items was silver bullion, which fluctuates, by the day. So I couldn't have been able to do the restitution hearing on the same day as sentencing.
Let me just read the minutes because my understanding was we weren't going to have it the same day either. Attorney Stroud makes a statement about restitution. Court responds, addressing defense attorney Stroud responds, requests restitution hearing, court addresses, blah, blah, blah. Accepts state's proposal, stipulates to $124,631.47, request restitution hearing. That's what I have in the minutes. I don't know. There was a stipulation to apparently the $124,631.47. Is that part still stipulated too? It's just anything beyond that?
That's correct. Basically, the victim had given one value at the start of the case. Defense didn't know why it went up so substantially over the course of the case. So the restitution hearing's about that.
Honestly, I don't recall off the top of my head if it was stated that we would have it today. It's just scheduled as a sentencing hearing, and my clerks would have done sentencing hearing and restitution hearing. It would have been double booked. I prefer to have them the same day, but I'm not the one arguing them. So we can't do it today?
I can't do it today. To give you an example, the price of silver bullion has changed 4% today, meaning we're talking about like $10,000 in one day in terms of the value of the property. For restitution, the value is affixed at the day of sentencing, which makes it really hard to do this restitution hearing for the victim until the sentencing hearing date has been affixed and we know the silver bullion value on that day.
Okay,
So basically the restitution is going to be a different number than anyone has seen before because of how it was determined.
all right. So is this something you would like to be in person, Mr. Stroud? And is this going to be a half of a day?
I think I'm only going to have two witnesses. It's going to be the victim and it's going to be the jeweler who did the assessment.
In addition to that, we had Deputy Krupa. We had her subpoena for today as well. She's here.
That's why she's here. Thought we needed law enforcement, and I didn't understand why. All right. Well, Deputy Krupa does not have to make any statements as it relates to value, does she, Mr. Stroud?
She received a list from Mr. Fry, took a statement from him. It was on body camera video.
I have June 23rd all afternoon open.
This is the issue. I am going to be in trial prep for a week-long trial at the end of June, and I'm going to be gone all of the month of July.
What does end of June mean?
June 22nd through the 3rd.
Well, I just had opened up.
Oh, I'm sorry, June 29th through the 3rd. I apologize.
Just had opened up, or it's almost guaranteed to open up June 16 anytime.
I don't know that I can get the jeweler here with 1 week notice. It's the jeweler from Spooner. I think that would put a lot on a local business owner.
I'm looking at, you said June 23rd in the afternoon?
Is there a possibility that we can adjourn so the state can see, maybe make a call to the jeweler?
Of those two dates, I prefer the 23rd. And if Attorney Schmidt wants to call the jeweler, see if he or she's available.
Well, the 23rd gives plenty of time. The 16th is what he's arguing wouldn't, so I can give you all afternoon on June 23rd.
All right.
All right. Anything else?
Not for me.
I don't know if Miss Honeycutt will still be in the jail at that time.
They'll keep her.
All right.
Because she does have a right to be here in person, so they will keep her. All right, then we are adjourned.